My lords and my lady, with your kind permission, my name is Ochieng Oginga. I do appear together with my colleague, Ms. Wangui Njoroge, who is present. On behalf of the petitioners, I will be relying on the amended petition dated 31st August 2023, together with the affidavit sworn in support of the same by Raila Amolo Odinga, written submissions dated 31st August 2023, and a list and bundle of authorities equally dated 31st August 2023. I wish to center my submissions on two broad areas, namely taxation and devolution, in light of the Finance Act 2023. Now, the first issue I wish to address is whether sections 2 and 84 of the Finance Act are unconstitutional. And to that extent, I submit that the two provisions are unconstitutional and in contravention of Articles 10, 110, 209, 186(2), and 210 of the Constitution. My Lord, pursuant to Article 110 of the Constitution, a bill concerning county government means a bill containing provisions affecting the functions and powers of county governments. Now, for that proposition, my lords and my lady, I refer the court to be guided by the decision in the matter of the Interim Independent Electoral Commission, that is Constitutional Application number 2 of 2011. That is contained at page 12 of my bundle, and more specifically paragraph 40, where the Supreme Court pointed out and stated, "We consider that the expression any matters touching on county government should be so interpreted as to incorporate any national level process bearing a significant impact on the conduct of county government." My lords. Now, in this case, my lords and my lady, section 2 and 84 contain provisions touching on entertainment tax and the housing levy. My lord, I submit, pursuant to paragraphs 8, part 2 of the 4th schedule, county planning and development, including housing, is a key function of county governments. And the role of the national government is only limited to initiating a housing policy. It cannot go beyond that. My lord, now for that proposition, I invite the court once again to consider the decision in the Law Society of Kenya versus Cabinet Secretary, Ministry for Lands. That is at paragraph 11 of my submissions. Now, more specifically at page 35 of my bundle, at paragraph 54 in that decision. Now, the court emphasized and stated the words housing policy and housing are used in the 4th schedule in respect of national and county government functions. Now, the mandate of the national government involves the accreditation, regulation, and promotion of quality assurance and technical capacity assistance in the construction industry at large, while the county government is involved in housing to the extent of planning and development within the counties. So that, my lord, housing matters are an exclusive preserve of the county governments. My lord, in further interpreting paragraph 8, part 2 of the 4th schedule, I invite the court to apply the principle in Tinyefunza versus Republic, whereby the Constitution is to be interpreted as an integrated whole, with each provision complementing and supplementing each other. Now, my lords and my lady, you'll be told that housing function is a socio-economic right under Article 43 of the Constitution, and hence it is a preserve of the national government. Now, I submit, my lord, whereas housing is one of the socio-economic rights under Article 43 of the Constitution, the Constitution is express when it lays emphasis on these socio-economic rights that are to be co-shared between the two levels of government. My lord, in fact, if you look at Article 204.2, for example, it specifically introduces the Equalization Fund. And it states, my lords and my lady, permit me to read, the national government shall use the Equalization Fund only to provide basic services, including water, roads, health facilities, and electricity to marginalized areas, to the extent necessary to bring the quality of those services in those areas to the level generally enjoyed by the rest of the nation so far as possible. So that in this provision, my lord, the services referred to are also contained under Article 43 of the Constitution. But in this case, the Constitution has gone further to specifically delimit these particular functions to denote that they can be co-shared between the national government and the county government. Now, my lords and my lady, secondly, Section 2 of the Finance Act introduces income tax on income generated from digital platforms. My lords and my lady, I submit that Article 209 restricts the nature of taxes to be imposed by the national government and restricts it in form of imposing entertainment tax, so that the digital platforms income encroaches on entertainment tax under Article 209 of the Constitution, so that again the Act itself encroaches on the mandate of the county government. My lord, again, under Section 2, the digital content monetization as defined under the Act is ambiguous and uncertain, my lord, and the same is contrary to Articles 186.2 as read with Article 209.3 of the Constitution. Now, I refer the court to the decision in Real Deals Limited and 3 others. That is authority number 3 in my bundle of authorities, and more specifically, page 56 of my bundle, and that is paragraph 72. And I urge the court to uphold the holding that, in my view, this is the court speaking, the respondents cannot be allowed to usurp the mandate and powers reserved to another state organ under the guise of collection of revenue for the country. My lords and my ladies, again, you will be told that the speakers made a decision and determined that the bill does not involve the counties. I submit that the determination of whether a bill concerns county government is not an exclusive preserve of the speakers of the two houses. This court has the ultimate powers pursuant to Article 165 of the Constitution to determine and make a pronouncement on that question. So that in this case, that decision is being treated as if it is a private affair between the two speakers. But we submit that is a decision, an administrative decision, that is subject to review by this honorable court. And hence, this court reserves the exclusive jurisdiction to determine the validity of a decision by the speakers made under Article 110, Subclause 3 of the Constitution. My Lord, now on taxation, on the second limb of my submission, first I begin by saying that it is trite law that legislation needs to contain certainty and clarity. So that this principle, my Lord and my Lady, has been described as a fundamental tool in the legislative process. Now, permit me, my Lords, to refer the court to the article by one author, Alexander Deming. It is titled Certainty and Uncertainty in Tax Law. That is a Siberian Federal University Journal publication. Now, my Lord, I refer specifically to page 133 of my bundle, where the author identifies 4 key elements underpinning clarity in taxation law. Permit me, my Lords, to read. First, the author points out that certainty in law is the cornerstone of the state governed by the rule of law. The lack of certainty in law deprives it of its ability to perform its functions effectively, to form a stable legal order, and to direct, in bracket, guide people's behavior in particular. And then, finally, the principle of certainty of taxation is the ideological basis of all modern taxing systems. Now, secondly, my Lord, permit me to refer also to the 7th article on my list of authorities. That is Daniel Dick. The article is titled Neutrality and Legal Certainty in Tax Law and the Effective Protection of Taxpayers' Rights. This is an Acta Juridica Hungarica, Budapest journal publication. So that for that article, I refer the court to page 163 of my bundle, where the author points and says, taxpayer rights can be exercised effectively in a well-established system of tax law. It is important to look for the quality of tax legislation, in other words, to know about the conditions in which the tax law can be considered as ideal. It should apparently rest on a sound normative basis. My Lord, the other authorities I also wish to rely on and articles, but the upshot of the submission, my Lord, is that tax legislation has to be certain. So that in applying these principles, my Lord, if you look at, for example, the housing levy, first, what is apparent from the responses tendered so far is the definitional challenge. We don't know, the taxpayer does not know whether it is a levy or a tax. What is it? That is the first definitional challenge, which ought not to be the case for any taxing legislation. Secondly, the imposition and enactment of that provision ought to have involved both houses of parliament. Again, the housing levy is uncertain on the mechanisms that will be used to achieve affordable housing. It fails, for example, to disclose how the funds will be computed, raised, disbursed, and utilized, my Lord. Again, on the final issue, on the legality and constitutionality of the Act, I quickly point out to Section 33 of the Act, which introduces VAT on compensation. So that in that context, my Lord, Section 33 is contrary to Article 24 of the Constitution, as it introduces a limitation on the right to property under Article 40. And it does not pass the threshold for limitation of rights. Finally, as I conclude, my Lords and my Lady, I urge the court to allow the petition, and I invite the court to reiterate the findings by the Supreme Court in the matter of the Speaker of the Senate, that is authority number 10 in my bundle of authorities, where the Supreme Court was emphatic and stated as follows: it emerges that Kenya's legislative bodies bear an obligation to discharge their mandate in accordance with the terms of the Constitution, and they cannot plead any internal rule or indeed any statutory scheme as a reprieve from the obligation. Then secondly, the Constitution vests the legislative authority of the Republic in Parliament. Such authority is derived from the people. And finally, my Lord, pursuant to Article 93(2) provides that the National Assembly and the Senate shall perform their respective functions in accordance with the Constitution. So that as I close my submissions, my lords and my lady, any legislative process that falls short of the constitutional muster can be best described as legislative deception. That's all, my lord.
Thank you very much.